is reading the legislation in its entirety to know and understand what they're all about. So that's what I have done. I went back to the original 1932 Grand River Valley Commission was the first act, and it was 7 pages long. And they always had to enter into an agreement or expropriate. Then, in 1938, it became a formalized document, but it was still the Grand River Valley Commission. It was the original Conservation Authorities Act that was passed in 1946 for all of the conservation authorities. And there is nothing in that act that gives them the authority to regulate your private property unless you let them. See, people that are enforcing these laws, and I'm going to tell you a little story. I had to go to a public meeting for an official plan. And the Conservation Authority in that area was going to be expanding their mapping, Elizabeth, to regulate more private property. So one woman asked the representative of the Conservation Authority, who was a very tall, slender, attractive, blonde girl, who is supposed to be the permitting and enforcement officer for this Conservation Authority. So this one woman asked her about Section 21 and Section 28. Well, I really don't know that, so you'll have to contact me at my office so I have time to find out about it. This is the enforcement officer. This is the woman who says she is a peace officer with enforcement powers. Then she went on to ask, well, why were the conservation authorities created? Oh, well, they were created when Hurricane Hazel came through and we had to save lives. That's a quote. These are the people that are supposed to be the enforcement officers. This is a joke. She may have a university degree, and she may know about guppies and trees. But if she's going to be doing enforcement as a peace officer in this province, she should know the legislation, and she obviously doesn't. The other thing is, with the letters patent, time to explain those. The letters patent are, technically, the writing of the sovereign sealed with the Great Seal, where a person or entity can do things they would normally not have the authority to do. They are to be open to confirm that authority. What they really are, they are a contract between the original settlers, their heirs and assigns, people that they would sell it to, and so on and so forth, or transfer it to, and the Crown. This involves the Crown prerogative. If it wasn't for the Crown and the Crown prerogative, we wouldn't have any provinces. We wouldn't have the Dominion of Canada. And if it were for letters patent, we wouldn't have it either. These documents are a law, and they are a contract. They are an act of Imperial Parliament, and they are your private property rights. Because under Section 109 of the British North America Act, it states, the lands, mines, minerals, and royalties of the provinces at the time of union subject to any trusts or any interests not of the province in the same. That is your private property. Because the Queen in right of Ontario, according to the Roundtree Beach Association versus the Attorney General of Ontario, 1994, the Queen in right of Ontario has no right, title, or interest in the lands described. And according to the Midland Free Press in 2000 regarding that case, you cannot plan for it if you don't own it, And public user rights only become those rights upon the successful application of the Attorney General in the Superior Courts. So what I'm trying to say is, number one, the letters patent, if you're in the lower courts can't even deal with them. This is Superior Court or Supreme Court of Canada stuff. So, this is why we have set up the litigation fund for the Ontario Landowners Association. We have our first case on the go right now, and you're all going to be going, The first case, we are doing a constitutional challenge on the OSPCA. The reason being, it is not only the farming community, as per, can't remember his first name, his last name is Draper. According to Mr. Draper, farms are an opportunity for the OSPCA. That's a quote. The other reason is, the OSPCA on an anonymous complaint went after a handicapped woman with a lap dog, because they were told it may have tartar on its teeth. You laugh. They got a warrant. 3 OSPCA agents and 3 police officers showed up at Jessica Johnson's door. Jessica Johnson, because she is handicapped, she has problems sleeping, she takes sleeping pills and was having a nap on her couch. The OSPCA agent went around to the back and broke in through her bedroom window and went and let in the other 5 officers. The OSPCA agents could not determine on site whether the dog did or did not have tartar on its teeth. So Jessica was hauled up to the Animal Care Review Board. Everybody hold on to your hats. Who in the world do you think was prosecuting this little handicapped lady? None other than Clayton Ruby and his assistant. And for 6 days, they went after this lady, and you know what they got her for? Obstruction of justice. People throughout Ontario are dealing with this day in and day out. The OSPCA was created in 1913. I have their original letters patent. And there are only two things that are different about the original act and the act today. The first being, they used to be under the supervisions of veterinarians. And the second being, they put the word distress in the new act. If you tease your kitty, if you give Fido a milk bone and get him excited, you are distressing your animal. I'm serious. So we, the Ontario Landowners Association, have decided that because the OSPCA feel that, and this is according to one of their agents, they have badges that are real power, we have decided that it's time to neuter and spade the power. So, that being said, in the last 2 years, I have been working with Terry Green. He, like I said, is a lawyer in Ottawa. Terry's winning lots. Because every time I do a report, I send it to Terry Green. So Terry Green has been on a steep learning curve for the last 2 years, but he's learned ample. Because as I've already mentioned before, no one is reading the legislation in its entirety to know and understand what it means. The Municipal Act, the one Municipal Act, is close to 400 pages. Do you think a councillor can sit down and read 400 pages of legislation, even though he is obligated to under the Councillor's Guide of 2010? every elected official in this province is to know and understand every piece of legislation that pertains to them. Our municipal councillors are to know and understand 80 pieces of provincial legislation. That does not include regulation or policy. They are also to know and understand every piece of federal legislation that pertains to them, every regulation and policy. And they are also supposed to know and understand the constitutions of Canada. There are very, very few people that know all of this. I have been reading legislation for 5 years. And it was when, actually, it was kind of fun. The Ontario Bar Association did actually a paper on the letters patent. And it gave me a title for almost all of my reports. Because they were going back off government, what municipal councillors need to know about the letters patent. Fred Probst, back there, Norfolk Landowners Association, sent me a copy of that report. I was very disheartened to see that the lawyer that had put that report together had not finished reading the documents in their entirety, and to explain that the 1836 Act of Crown Land Protection, actually if you went 3 or 4 pages later, you would find the Private Property Trespass Act. Because Crown land is ungranted land. It is unpatented land. And according to the court case of 1935, which was the Attorney General of Manitoba versus the Attorney General of Canada, it lays it all out there. This is how it worked. You're a settler. You wanted land. So you would go and you would get yourself a location ticket, or, are we ready for this term, an occupancy permit. Then, you were allowed 3 to 5 years to clear a certain amount of land, build a house, make sure you could sustain yourself. In that time, the magistrate would come along and check on you. And in that time, that property could be regulated by government. Once the letters patent were issued, once the magistrate signed on the dotted line and put the seal on it, that was it. Then there is this 60 years that everybody's going, what is so important about the 60 years? The 60 years is based on the Nullum Tempus Act of 1769. And that's because we had another nasty King John, and he would grant people land, and then he'd take it back and give it to somebody else. So, Parliament, the barons, these officials, decided to clip the wings of the king. So, they created the Nullum Tempus Act, restricting it, that once he granted that land, if that person kept that land for after 60 years, there was no taking it back. And if you look at Section 3 of the Real Properties Limitations Act of today, you will see the Crown or any of its agents after 60 years have no force or effect on private property. See, these are all pieces of legislation that none of you have actually even heard of, have you? Does anyone know that in this province we actually have a Property and Civil Rights Act? It's one paragraph. Bob Ray did it. And it's been hidden away. And in that paragraph, it refers you to the Constitution of 1792. And in the Constitution of 1792, it was to bring the laws of England in regards to property and civil rights to Canada. But the crazy part of it is, if you go to Chapter 81, subsection 9 of that document, page 1283, joking, it states right in it that once the letters patent have been issued, there is nothing, and even in future. So then we come fast forward through to 1867. Who here knows that the British North America Act of 1867 is actually your real constitution? You know that thing from 1982-83 that Trudeau brought in? That so-called Charter of Rights? I refer to it as the Charter of Removal of Rights. In 2 sections of that document, they can remove your inalienable rights. They can remove your life, your limb, your liberty, your freedom of speech, your freedom of religion, but they can't remove your property rights, which you already have guaranteed under the British North America Act and common law, because property rights are not in the Charter. You see, Section 1 states that if something is justified in a demonstratively democratic society, they can remove your rights. They just did it with a fellow named Whatcott. Doesn't matter if you're telling the truth, your freedom of speech can be removed if you hurt someone's dignity. So, if Wayne Island were to say to me, "Gee, Liz, you've put on quite a bit of weight since you become a landowner from sitting on your butt reading legislation," I could haul him in and have him charged for insulting my dignity. And if he decided to appeal it to the Supreme Court of Canada, he would win if he did a charter challenge. I'm not the person that's saying that we have all these rights. I'm relying on the Canadian Bar Association from 1948. In 1948, the Canadian Bar Association was very concerned about Canadian civil liberties. The war was over, people were coming home. Government had spare time on their hands, and the bureaucrats had, 5-6 years to run around and create bundles of legislation. So the Canadian Bar Association had a meeting. And they're saying, well, look, all of our inalienable rights, which are life, limb, liberty, freedom of speech, freedom of religion, and private property with the freedom of contract, are already protected and guaranteed under the Constitution, being the British North America Act, because of the preamble of the Act, because of the way it was written. So what we don't need is a constitutional document, we just need a statute. So they tinkered away and tinkered away and tinkered away with that until Diefenbaker came out with the statute, which is known as the Canadian Bill of Rights in 1960. Well, there's one problem with that. Unless it's a piece of federal legislation, it's not applicable. So, in the provinces, well, the British North America Act was bastardized in 1881. And that was interference by parliamentarians with the Privy Council in England. Because it is the federal government under Section 91 that has peace, order, and good government. They are to be the dominant legislators in this country. The provinces are subordinate. Section 94. The federal government may create legislation in regards to property and civil rights. The provinces have the option of whether accepting it or not accepting it. But that didn't grant them the authority to create any legislation for your private property. How do I know that? There was a Supreme Court case in 1881 just prior to the Parsons case. And it is Mercer versus the Attorney General of Ontario. Anybody who wants to read a really long court case that explains all about Canadians' rights should get a copy of it. Mercer has been cited today, in 2009. The other court case you may want to look at is the College of Dartmouth versus Woodward from 1819 in the United States. Because of my position on the Canadian Justice Review Board, I am actually able to get my hands on the latest Black's Law Dictionary. It's the 9th edition, 2009. In that dictionary, if you read through all 1,500 pages, you will find that the Dartmouth College case is cited. And what it said that was kind of rang in my ears was that had the legislators wanted to be able to regulate, they should have reserved it in the letters patent at the time of issuance. So I'm all about patents, I'm all about constitutions, and I'm all about legislation. Because there is nothing in any pieces of legislation, perhaps except the Environmental Assessment Act. Do you know that you are either on the same level or less than plants and animals? Did you know that under the Environmental Assessment Act, your bathroom and kitchen are considered part of what the province should be able to regulate? It's everything. In your vehicles. So to me, the Environmental Assessment Act needs to go, because obviously the province has overstepped in their definition based on the fact that Section 109, gee, can't be done. They can't interfere with your trusts and your interests, because they're the province's trust, the province's interests are subject to yours. So now this is where we get into the squeaky wheel getting the grease. You're all here tonight. When was the last time every one of you was at a council meeting? Who went to the last council meeting? I've been working for 2 years with the Reeve of Jocelyn Township. You know what he told me that was the niftiest thing I ever heard? He said to me, "Gee, Liz, have you ever faced a mob?" They were going to be passing their official plan. This Reeve is actually a member of the Landowners Association because he believes in private property rights. He told everybody in the community that they were going to be passing their official plan bylaw because the mayor generally either doesn't get a vote or he is only one vote. So he had 300 people show up at the council meeting. They did not pass their official plan. As it stands right now, there are five counties in Ontario that have not passed official plans. Because they can't plan for it if they don't own it. So now I'm going to get into the Municipal Act for about 3 minutes here, and it's like this. Okay, so under Section 10 and 11, subsection 2, Section 4 of subsection 2, which is bylaws, Section 4 states that the municipality may pass bylaws to acquire assets, to exercise its, being the corporation, authority under the Municipal Act or any other act. So there's no definition in the Municipal Act of municipal assets. So I found Regulation 59906. And municipal property assets are land, equipment, and goods. So, if the municipality has not acquired the land, has not acquired the equipment, or has not acquired the goods, how can it possibly exercise any authority under the Municipal Act or any other act? On private property, I don't think so. In the Planning Act, Section 24 is all about public works. Section 25 states, gee, gotta acquire the land. Part 5, Section 28 through Section 33. That is community improvement. Do you want to know what the first few words of the definition of community improvement are? Any planning or replanning. And they have to acquire it. Do we understand now that no one is reading the legislation? It's very concerning to me Lawyers are not reading the legislation. Who here in this room wants to pay a lawyer $500 to read 400 pages of the Municipal Act to understand it? What lawyer has time? Same with the Conservation Authorities Act. Do you know that there's the Municipal Franchise Act for oil and gas? Did you know that there's the Municipal Elections Act, which they are to know? Did you know that there's the Municipal Amendment Act that they are to know? That's just 3 or 4 off the top of my head. And on top of everything else they're supposed to know, they are to know every past bylaw, and they are to know all of the past finances up to the present. And they are to keep tabs on any court cases. And a lot of them have not kept tabs on that, or they would know about Moyer versus Georgia Bluff, where a bylaw inspector decided that a guy named Jim Moyer had a messy yard. So he went to Jim, and he said, Jim, you got a messy yard, you need to put up a fence. Now, Jim was a pretty creative guy. He went around to all the local businesses and he got all their old used skids and he stacked them up. He had himself a privacy fence. Well, I guess the bylaw inspector thought that this was just Jim being rude and maybe perhaps insulting him. So the bylaw inspector got a crew together, and not only did they take away his privacy fence, they went and took a lot of his fine quality stuff off of his property to the wrecking yard. Jim Moyer is a very rich man now. You do have options. He sued. And in the ruling, the judge states, bylaw officers are to know and understand the limitations of their legal authority and that the township had committed a trespass. Because if you actually look at the building code, section 15.1 to 15.8, which is municipal property standards, it is actually restricted by sections 1.1 and 1.2. I busted municipal affairs on that one. You contact municipal affairs and you say to them, where does the municipalities get their authority to create property standards bylaws? And really quick they'll get back to you, well, that's section 15.1 to 15.8 of the building code. So when you slap them back with, well, what about section 1.1 and 1.2? And oh yeah, section 35, municipal bylaws. The only authority they have to create any bylaws under the building code is section 35 and the procedures for the chief building inspector. Because section 35 will refer you to actually section 10, and that is to do with public sewer and water only, and your hookups. And when you are going through the Municipal Act, you will find sections in regards to private roads, and how they have no authority over private roads. And they actually have to seek your permission to hook up sewer and water. So what would make anyone in this room think that a municipal corporation, because that's what they are under Section 4 of the Municipal Act, they are Simpson Sears. They are Canadian Tire. You are the shareholders. You elect the board of directors. The board of directors has staff. And in the Councillor's Guide, that's who they're told to listen to. Every section of the Municipal Councillor's Guide from 2010 tells them, listen to staff, talk to staff, talk to staff. But when they get into chapter 3 of that, municipal councillors as lawmakers, oh, no, don't talk to staff, they can't give you legal advice. So then we're back to dealing with the municipal lawyers. It was a municipal lawyer that wrote the document on the letters patent. And the reason I'm on the Canadian Justice Review Board is I busted her. So, did we learn lots tonight? Now, the next step. You all have to start standing up for your rights. This is why there is an Ontario Landowners Association. The Lambton Landowners, Bill is back at the back, Bill O'Brien. He's the president, he's also on the executive of the Ontario Landowners Association. He and the Lambton landowners actually stopped an inspection of the Thetford sawmill by the Ministry of the Environment. I worked with the owners of the Thetford sawmill's lawyer. We did up a letter and we explained to the Ministry of the Environment about the letter's patent and how if they came onto the Thetford sawmill's property, they would be trespassing. Gee, the sawmill passed their inspection and nobody came on their property. The other thing is, throughout Ontario, we have had 8 sawmills closed down. Yeah. Did you know that sawdust is hazardous? Yeah. And there is a regulation out there, and the regulation is 419/05 or 06. The Ontario Bar Association actually sent a letter to the Minister of the Environment, that would be John Garrettson, who is now our Attorney General. And it was explained to him that Regulation 419/05 or 06 is unconstitutional. That was the same regulation that they were implementing on the Thetford sawmill. We won. Anyways, I got the nod, I gotta go. Anybody wants any questions after? I'll be hanging around for a bit. Oh, he wants me to do a 5-minute question period. Sorry, go ahead. Yes, I'm not.
Oh, I was just going to say, we got time for maybe one question. Okay, want to stand up and shout it out, please?
What was the National Heritage Act? How do you get around that?
Well, heritage is for, actually I'll go back to a court case, and it says if the soil is not in the Dominion, then the regulation is illegal. So if it is the national heritage, then if they don't own it, they can't plan for it. It's right in our Heritage Act too. Let's see, that section in our Heritage Act, in the province. It is section 36 through 39. In regards to the national one, I have not read it. But
the provincial one, they're rezoning the land around here.
What they're trying to do is they're trying to implement Part 5 of the Heritage Act, and that is for heritage district designations. There's one problem with that. When you get down to section 45 of Part 5 and 45.1, it refers you back to sections 36 through 39, which means they have to enter into an agreement. There has to be either an easement or a covenant lodged or registered against the title, or they have to expropriate it. Either that, or tell them to get off your property.
Well, I've been informed that they've rezoned these areas here, and they are trying to show their authority and control these lands.
So are you going to the next council meeting to tell them that that's unacceptable, because all zoning is actually a designation, and nothing can be designated by anyone else but the private property owner through dedication by grant in deed. And you may want to get a copy of Grist versus Meaford 2013. Okay?
Okay.
Thank you, and thank you for coming.